What are your thoughts on this verdict of not
Disappointed but not surprised. The comments that the court made during closing arguments sort of predicted where the court was going. And if you listen to the testimony in terms of the contradictions and so forth, you got to remember that in terms of criminal law, the standard is beyond a reasonable doubt, not a preponderance of the evidence, not who do you believe more than who you do not believe, but beyond the reasonable doubt. And that's a difficult standard. And here between the medical examiners and the conflict in the medical testimony, and the conflict in terms of the police department, in terms of the preliminary investigations, it seems to me enough reasonable doubt was raised to justify a not guilty verdict, although there were some areas which you could have concluded beyond a reasonable doubt, in my opinion, in terms of misconduct, in terms of reckless endangerment, but the court didn't go there, so I can understand which way the court went.
You say you're disappointed but not surprised. Even that you're not surprised that any of these didn't go through? There's 7 counts altogether.
Listening to the trial and reading the conflicts that came out, and I've said all along, particularly in the medical examination, as you have a conclusion of a homicide, but a conclusion is where the injuries occurred and the fact that nothing was related to the officers outside in terms of the original takedown. I think that was enough to confuse people throughout, people that were involved in the trial, people on the jury, as well as citizens in general. So she had some difficult hurdles based on the charges that were placed, and that's another whole area in terms of how that came about.
And for our viewers who aren't as well read on this and up to speed, can you sort of explain what that means with the medical examiner and the whole word of this? I never said this was an accident, and why that became confusing possibly in a courtroom.
Well, when you have the possibility, just the fact that in terms of the production of facts, that the medical examiner might have concluded that it was an accident. Including an accident, that really doesn't justify the determination of homicide. And that was the whole basis for being able to bring criminal charges. Ms. Mosby had to wait till she had a homicide in the medical reports to even do that. And then you have the issue that was challenged by, I think, 3 particular medical experts in relationship to where death occurred or where the injury occurred to cause death. Whether it was in the van, what stop it was made, first part, last part, and what have you. This was relevant in terms of what Officer Goodson knew and when he knew it, and whether or not he was able to really observe Mr. Goodson in distress. And so all of that, of course, and as I said before, in terms of having separate trials, which was a great strategy, a lot of it predicted by law that Judge Williams had no choice but to grant separate trials. But a lot of that allowed them to play a certain throw the blame game down the street in terms of, like I said before, the shell game, under which shell is the P, and they were able to do that successfully as a defense. And so, and by the fact of going with a judge instead of a jury, that took out all the elements of emotion and so forth, that somebody's got to be responsible, because we knew that Freddie Gray was alive, we knew he was not injured when he was arrested, and he's injured, his neck is broken, somebody has to be responsible. A jury would get emotionally involved in that. A judge does not have to.
And what about moving forward? What are your thoughts on that? Because if Officer Goodson was facing the most serious charges, what does that mean for the other officers who are awaiting trial? And where does, where does it go from here?
I think that's really going to strain the credibility of the state to, in fact, successfully prosecute the remaining officers, Porter in terms of a retrial and the other remaining officers. I think the prosecution really at this point in time, I can't even say they can make deals, but I think the prosecution is really going to have to reevaluate as whether or not they have the legal ammunition to waste the taxpayers' time in terms of proceeding on the remaining trials.
Do you think Marilyn Mosby's credibility is in jeopardy?
I think, of course, she's going to receive a lot of criticism, and then some of that's going to come out in these defamation suits that I heard you mentioning earlier. But I think the majority of the citizens of Baltimore City support her in have the tenacity to bring the actions in the first place. Because in so many cases I've been involved in, we go into the state's attorney's office, if we get the privilege to go in, and they tell us, we've done an investigation, there will be no prosecution, period. Game over, ball game done. And so I think by the fact that she into areas where few prosecutors would venture to go gives her a lot of credibility with the community. Of course, mistakes were made. The question is going to be, was it a rush to judgment in terms of the indictment? But it's easy to play Monday morning quarterback if you can take yourself out of what was happening at the time.
Okay.
At the time, she had several things to look at. It wasn't her responsibility to save the city, but the city was exposed. And she was getting reports from the medical examiner's office, like immediately overnight, she had to make decisions.
We are looking at a live picture of the courthouse, and I was just told that Warren Brown is at the podium right now. We're going to hear from him right now.
During the case, clearly the state failed to present evidence sufficient to convince this judge. And in fact, throughout his opinion, he notably mentioned over and over that the state had failed to present evidence to support their contention. And so therefore, it's easy to understand how he could come to this decision.
But Warren, moving forward with these cases, does the state still pursue these trials against the other officers?
Well, I think the state has some problems moving ahead. I think they've got to consider the fact that Sheriff Cogan most recently indicated that he had not been involved in any investigation, contrary to what the state had indicated, what the state's attorneys had indicated. So therefore, one has to wonder about the credibility of the cases that remain. And I think that there will be motions made on the part of the defense attorneys indicating that both Bledsoe and Michael Schatzow ought to be able to be subpoenaed to testify about their involvement. Now, this is allegedly their strongest case, and as you can see, they fell flat on their face in this regard. And so whether they continue, I'm not sure. I think the original prosecutions were political. I think that the decision to proceed against these other three officers will be a political decision as well. That is, how it's going to impact on Marilyn Mosby's political career, whether I go forward or whether I dump these cases, which she should. I think there is a body of people who believe that these cases should never have been brought, that there was a rush to judgment, that it was an attempt to both placate the uprising in the city and also to support her political ambitions. And I think that that's the problem with putting a politician in as state's attorney. They make political decisions and not decisions that are intended to impact on public safety.
So, Mr. Brown, right here, just what's next now?
Well, it's up to the state to decide whether to proceed with
That's
the
Warren Brown there, and he's saying, Warren Brown, attorney, who's been watching much of this case. We've been tuning in with him, saying a lot of this, in his opinion, is political in nature, and he thinks that it'll continue to be that way, he says, with the remaining trials as well.
All right, now we're going to send it over to Dave Collins, who has been covering this trial and was just in the courtroom listening to the verdict. Good morning, Dave. What can you tell us?
Hi, good morning. You know, the courtroom, to the sheriff's deputies' credit, there was no obvious reaction. The courtroom was quiet. They left quietly. Officer Caesar Goodson had his back to us. He seemed very motionless, actually, just intently listening to the judge's every word. Didn't see any obvious reaction. I am standing with Professor David Jaros. He is with the University of Baltimore Law School. And Professor, let's start with Goodson's reaction. You had a better vantage point than we did. Did you see him do anything to react to what happened to him?
You know, he was very stoic. He was clearly very focused on what the judge was saying, but there was not a lot of emotion there. Some family members were in the audience, and they certainly were upset, and I'm sure pleased with the outcome.
The judge, from the get-go, it seemed, the judge kind of led us down a path of where he was headed. What kind of hints do you believe he gave almost off the top regarding second-degree murder, depraved heart?
Well, there were really two keys to his decision. The first was, despite what the prosecutor may believe happened, and may well have happened, the evidence simply wasn't there to prove that a rough ride occurred, that there was any intent on Officer Goodson's part to injure Mr. Gray during the course of the transport. And that was really important for a lot of reasons, particularly in proving the wanton and reckless disregard for human life in depraved heart murder. But throughout all the charges, what was important to recognize is that Officer Goodson had to act more than unreasonably. He had to be aware of the risks risks he was taking. And at the end of the day, I think most of what the judge focused on was his own subjective awareness of what was happening and whether he could conclude beyond a reasonable doubt that Officer Goodson was aware of the risk to Freddie Gray and aware of what he needed to do, and that just wasn't proven beyond a reasonable doubt.
The prosecution throughout its presentation wanted the judge to take a look at logical inference, and as the judge told everybody, that simply was not enough. Talk a little bit about inferences and why could not have led the judge down a legal path to consider any conviction.
Well, so it is not inappropriate for the prosecutor to argue inferences. We use what's called circumstantial evidence and other evidence to infer a variety of things. Rarely will a defendant give us his intent and say, I'm trying to kill you, but we can infer it when you pull the trigger and point it at me. But the problem here was it was only one of some other inferences that could be made. And so in order to conclude beyond a reasonable doubt that they had been successful, it had to be the only reasonable inference, and they just didn't have enough evidence for that.
When Officer Goodson was charged, he is the only officer out of the 6, as you're well aware, that never provided investigators with a statement. Of course, he didn't take the stand in his own defense. He really didn't need to. How important is that decision on Goodson's part not to provide a baseline in which the prosecution could use?
You know, it's always a really difficult question. I think the judge, rightly, and everyone needs to recognize the defendant has no obligation to prove his innocence. He is completely entitled for any reason at all to keep his right to remain silent and say nothing. There is always a concern when there's a jury that a jury, despite being instructed not to take this into account, will hold it against a defendant. And that may have been part of what informed the defendant's decision to waive the jury, because I think he was confident that the judge would not take that and hold it against him.
Okay, we've had a hung jury. We've had 2 acquittals now. What is the prosecution's office expected to do from this point forward? What kind of meetings are they going to have? What sort of discussions do they need to have regarding the cases going forward?
I think the prosecution will sit down and review the evidence that they have. What is clear is now we've seen a pretty full showing of what they have. And the question they need to ask themselves is not, do we think a crime was committed, but whether or not we have enough evidence ultimately to prove it beyond a reasonable doubt. It is true, though, when you look at this case, at every turn, the prosecution has aggressively sought to get a criminal conviction here. I think no one can suggest that they pulled any punches, and that may be important. In fact, if we pull back and look across the nation at issues involving the police and death at the hands of police officers, that this would be a first time where a state's attorney has gone this aggressively. And there are critics on that side, and there are people who will praise that. So I don't know we can say for sure how they'll proceed. This does not bind them in a legal sense from what they can prove, but I think they're going to have to do another assessment.
Thank you very much. Professor David Jaros, University of Baltimore School of Law.